Hi, my name is Eileen Bounce, and I am going to be doing some jury dictation for you. It'll be rather quick. I will probably go about 3 minutes. Ready to write. Ladies and gentlemen of the jury, now that you have heard all of the evidence and the arguments of counsel, it becomes my duty to give you the instructions of the court concerning the law which governs this case. It is your duty as jurors to follow the law as I shall state it to you, and to apply that law to the facts as you find them from the evidence presented in court. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Neither are you to be concerned with the wisdom of any rule of law stated by me, regardless of any opinion you may have as to what the law is or ought to be. It would be a violation of your own sworn duty to base a verdict upon any view of the law other than that given in the instructions of the court, just as it would also be a violation of your sworn duty as judge of the fact to base a verdict upon anything other than the evidence presented during the trial. In deciding the facts in this case, you must not be swayed by bias or favor as to any party. All parties should be treated as equals, whether persons or corporations no longer in business. Our system of law does not permit jurors to be governed by prejudice or sympathy or public opinion. Both the parties and the public expect that you will carefully and impartially consider all of the evidence in the case, follow the law as stated by me in these instructions, and reach a just verdict regardless of the consequences. It is your duty to determine the facts, and in so doing you must consider only the evidence I have admitted in the case. The term evidence includes the sworn testimony of the witnesses and the exhibits admitted by the court during the trial. Those exhibits will be provided to you for your review when you return to deliberate. Remember that any statements, questions, objections, or arguments made by the lawyers are not evidence in this case. While you should consider only the evidence in this case, you are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified in the light of common experience. In other words, you may make deductions and reach conclusions which reason and common sense lead you to draw from the facts which have been established by the testimony and evidence in the case, but do not speculate about possibilities that were not fairly proved. Now, I have said that you must consider all of the evidence. This does not mean, however, that you must accept all of the evidence as true or accurate. You are the sole judges of the credibility or believability of each witness and the weight to be given to the testimony. In weighing the testimony of a witness, you should consider the relationship of the plaintiff to the defendant, interest, if any, to the outcome of the case, the manner of testifying, opportunity to observe or acquire knowledge concerning the facts about which the witness testified, candor, fairness, and intelligence, and the extent to which the testimony has been supported or contradicted by other credible evidence. You may and should accept or reject the testimony of any witness in whole or in part. Some witnesses are permitted to give opinions because of specialized training, education, or experience. For any such witness, you may weigh the reliability of any testimony or opinions. Consider whether the witness has enough training or experience to form the opinion in question, whether any facts necessary to support an opinion have actually been proved, whether another opinion better supported or better fits the facts which you conclude are proved. A witness may be discredited or impeached by contradictory evidence by showing that he testified falsely concerning a material matter, or by evidence that at some time the witness said or did something, or has failed to say or do something which is inconsistent with the witness's present testimony in court. If you believe that any witness has been so impeached, then it is your exclusive province to give the testimony of that witness such credibility or weight, if any, as you may think it deserves. The party asserting a claim has the burden to prove that claim to satisfy the legal requirements I will soon lay out. To satisfy the burden, he or she must persuade you that each of the legal requirements probably occurred. Probably means more likely than not. It means 51% likely to have occurred if it does not require proof to an absolute certainty. It is not every fact which may have been discussed which must be proved to a probability, but the legal requirement which must be so proved. Your job is to decide the facts based upon the evidence that you saw during the trial. The evidence includes the testimony of witnesses and the exhibits that I admitted. You will be given the exhibits in the jury room. In deciding the facts, you must not be swayed by sympathy or prejudice toward any of the parties. My job is to give you the law. After you decide the law, you need to apply the law that I give you, even if you do not agree with it. Remember that statements, objections, or arguments made by the lawyers are not evidence in the case. The lawyer's job is to point out those things that are most significant or most helpful to their side of the case. You should also not assume from any statements that I have made that I have any opinion about how you should decide the case. Okay, that was just about 3 minutes. Good luck.